hard work. And now we'll discuss the document. Who would like to? Yes, I'm going to the community first.
I just would like a point of clarification. I saw the packet that went out and the proposed resolution and the disclaimer, and I think they proposed a good solution to this problem. I'm a little confused about the reference Bruce makes to a memo. I know he wrote a memo on June 7, 2007, which basically was saying we should have the title companies determine what legal access is, and that would keep us in the county in the business of judging what legal access is, and I don't know what memo we're talking about.
I'll refer to that. Yeah, also, for the record, could you identify yourself?
My name is Chris Williams.
Thank you, Chris. The memo that we've been given here is a memorandum from the Calaveras County Surveyor to the Calaveras County Planning Commission dated April 17, 2008. Should be in public record, and I believe there are extra copies out there somewhere.
Okay.
Anybody have a copy for Mr. Williams?
And so basically the effect of this, though, is those two language changes that Bruce was suggesting.
That's correct, and those are the only things that have come into this with apparently the approval of council, departments, and the committees.
Thank you.
And not yet the board. We'll find that out shortly.
Good morning, Bill Smith from Mountain Ranch, and as you well know, I had an ox that was severely gored by the original proposal, or the way it was turned out, and I still think that the committee's result is entirely wrong. However, knowing that compromise is part of the deal, and having been allowed to sit in on a couple of those meetings as a member of the public, I'm eminently satisfied that the work that they produced is very workable, should keep everybody out of trouble for a long time to come, and I would sincerely recommend you adopt this resolution. I had a list of everybody I was going to thank too, but since Dave already took care of that, I won't do that. But these guys are, they did a great job. And boy, the discussion was spirited at times. And I also want to say thanks to Bob. My turn to say thanks to Bob for his work, and I hope you enjoy your return. A couple of days off.
Thank you.
Good morning, Mike Miller, Public Works Department. I also have Robert Packinger, the Deputy Director, here today, who's our in-house expert on the road ordinance. I'm sure if you have any questions, he'd be happy to respond to them. He's got a couple of comments of his own. But I'd like to talk about two things. I know when David made his presentation, he talked about recording and tracking the offers of dedication. They are recorded and they are researchable, and you can find them. What we do have is we have thousands and thousands of pages of old records that aren't digitized, that are in files in a warehouse near the road yard. And when David mentioned this to me this morning, I asked him what's the source of fees for getting this information in a format that's usable other than where it is today. There isn't a solution for how we can develop the fees. We don't have an idea what that cost would be. And my recommendation would be is you give us some time to figure out what it would take, if that's your direction, for us to get these maps made available. Some of them date back to the 1800s. And if that's the board's desire to have us do that, we'd be happy to research it, give you some estimates, and bring it back to you and tell you the amount of funds that would be required in the staff time to do something of that level. Secondly, I'd just like to point out that under Section A1 on that first page, the sixth line, or fifth line, it starts out prior to January 1, 1991, and is served by a road that substantially meets the design criteria. That's not a defined term, and we're not sure how you would interpret substantially meets. We have a road design criteria, we have a road template for everything, and we think that that's, in fact, I asked somebody, what does that mean? And they said, that's how compromises work. So we're just saying that from our position, if somebody says it substantially meets the road design criteria, that's not good enough for us to interpret. We're going to need it to either say it meets the design criteria, or somebody's going to have to define substantially meets.
While you're in front of us, actually, I was going to be asking this question later, but I'm interested in your thoughts on it. Since you raised it, I'll ask it now. Isn't there a third choice? You've given us two there. It's either fish or fowl. You're either in compliance or you're not. There's a third option here, I would think, which is if we were to designate a person to interpret that with an expertise in that area. So there seem to be three departments that this might fall to. One would be yours.
I would say
Any
that.
thoughts about that?
I would say definitely that if it says by a road, it's a public works responsibility to define. And if you say driveway, I would say it's up to the building department to define, and that's the way it is currently.
But one follow-up to that. The word substantial certainly has some art to interpreting, and the technology or the technical know-how to do that does seem to rest on a road issue within your domain. Do you feel confident that your department can handle this language and be able to interpret it fairly and reasonably and dispassionately with some technical application to it?
I'm going to defer to Robert because he's going to be here through the balance of his career, I'm sure, has been dealing with this for 14 or more years already.
I figured he might make an appearance.
Well, I guess to follow up on saying the other option is, I mean, it is or it isn't, and someone can always appeal for a variance, which has happened before. You know, I mean, that's the fourth option.
That's correct.
Steve says.
The thing that we've tried to do is standardize and stick by our standards, and we try to reinforce to people that when a decision is in the Public Works Department hands, and we make a decision by the rules that we have that don't change, then they do have the process of appeal. And we've had an item recently on a sign that we could not make a decision on, we didn't have the authority to. But when we do have the authority to make a decision, those are also appealable. So that's something that you can say, if we decide it doesn't meet our design criteria, a person could appeal to.
Have that right now.
They have that right on every decision we make.
Right. Thank you. I told you Mr. Wood had a comment, and then I'd be interested in hearing Robert's remarks.
I wanted to give you a sense of the committee's deliberations concerning the discussion of substantially. One of the things you'll notice in there is we use the state's road width of 10 feet, not the county's 12 feet. And part of the reason we use substantially was that if you had a road that you at one point measured 9.5 feet and another point measured 11 feet, you could say the average, or it's substantially was approximately a 10-foot road. As other counties explained, if people can ride a donkey, walk, ride a bicycle, parachute, bungee jump, whatever they have to do to access their property, they have the right to access. And so we were looking for the language that would give this county much of its historical situations of roads with unknown statuses that have been used for decades, if not a century, some flexibility for the county to continue to allow a reasonable property rights.
Thank you. Robert.
Good morning, Robert Packinger, Public Works. With regards to the question, if we are comfortable with implementing the language here in this section, we currently do not have a road template that would consist of a 10-foot width. That would be somewhat problematic. What we have for road templates are much wider. We've looked at roads consistent with the definitions that are in the county road ordinance, including the fire and safety regulations and the California Code of Regulations, which makes a distinction between driveways and roadways. That may need to be resolved in order for us to look at roads, in essence, that would serve more than one lot that are 10 feet wide. Another aspect in implementing what's proposed here is that when a person applies for a building permit, there is usually a requirement that they obtain also an encroachment permit. In past practice, when people come to us looking for an encroachment permit for situations such as these, there's been some confusion as to whether they need to meet a driveway standard for the encroachment to the county road or some sort of local road connection to the county road, considering that this, what is being called here a road, serves more than one lot. That will need to be clarified. Another issue that will need to be clarified is when the existing road needs to be moved for any reason. There have been issues, there was one issue in particular up in Forest, it might be in Forest Meadows or up in the Arnold area where due to steepness, there was a little access road that served various lots.
Ponderosa.
It might be Ponderosa. But because of its connection to the county road, it needed to be moved. So at that point, what standards would apply to this new connection and new roadway to serve these existing lots? These are vacant lots, and currently as it is now, there's maybe a 10-foot wide little easement that serves all these lots, but it's not viable due to terrain. Those are issues that would need to be perhaps addressed in order to effectively implement the ordinance.
Okay, any questions there?
That's a really good one that Robert talked about. Because of that, and the issue came to bear because a property owner came in and put a gate up and told people that you cannot cross my property to access yours. And there were however many parcels Robert talked about. And they had an easement, a legal easement, 10 feet, it was 10 feet wide. The terrain was terrible. It would cost hundreds of thousands of dollars to put that road in. And we've come to a tentative agreement on the access across the property, but that's just as good at the moment, and it could change next week. And those are good. And most of these issues are not in my district,
They're in
the
mine.
rest are Tom's and yours, and I'm assuming Bill. Thank you. Well, that was a good.
Thanks. Other people who wish to address the board on the topic?
Good morning, ladies and gentlemen. My name is Roger Pitto. I'm on the committee. I'll sign in here real quick. Number one, I think we need, at least the direction this committee was given, was to deal with access when determine legal access, that we said, well, you really got to have adequate access, and you know, it has to be, you have to have a right of access. We, in Chapter 1202, and I'll jump around a little bit because I usually do, in Chapter 1202, the exceptions in 1202 in the first or second section, it accepts roads to single-family residential properties. So the road ordinance doesn't deal with driveways to a single parcel at all. In 1992, our last ordinance, which was going to be updated some time ago, contemplated that a off-site driveway standard would be established in the zoning code, just as you have your parking standards and yet to be on-site commercial parking for multifamily and what have you, and that's not yet been done. So what the committee did, we said, what standard exists? The only standard that exists in any of the county codes comes from 4290, which is called 810, and we got into a little technicality about that. But that 810 talks about an on-site driveway serving no more than 2 or 3 homes or outbuildings on a single parcel. And it has a definition as the maximum. You've been involved with this before. It has a certain width. Under 810 is 12 feet. Under state law, it's 10 feet. It has certain maximum heights, grades and what have you, which you've been involved with. We said, well, okay, we have a clear definition of an on-site driveway. Let's use that same definition for the off-site driveway passing through the neighbor's house, the neighbor's property, or 4 neighbors' properties. And the reason that was chosen, well, when 810 was originally picked, the fire service that I was active in wanted 12 feet rather than 10. Right now, we believe, as lay people, that the current 810 is not legal because it's never been certified, and it needs to be certified and has errors in it in a lot of our opinions. So we brought back to the state law, which we think is what might now govern, but so we're using 10 feet. But that is just for a private driveway to one parcel. If he goes over 2 parcels, 3 parcels, or 4 parcels, but that's his driveway, that's fine. Now, if you get into a situation that you're serving multiple parcels, the developer is serving multiple parcels, then off-site from this guy getting his building permit, there would be road requirements pursuant to 1202. But our task was dealing with legal access to a single parcel. Why we picked January 1, 1991, because that is in state law the time that, notwithstanding what a few people say, that grandfathers in, for lack of a better word, all existing structures, parcels, roads, etc. So that's why we picked Jan 1, 1991. And essentially, Bob Selman, and Bob will correct me if I'm wrong, Bob was very concerned about not just legal, but adequate. So we tried to combine the two and come up with a minimum road and that for a driveway. And I've been pushing for years to develop a driveway standard, but I think we'll get to it pretty quick. Very positively, I hope we do. But anyway, and the idea was, if this parcel existed out there legally prior to Jan 1, 91, and you may not like our thought process on picking that date, but we have some basis for picking that date. And the building department, not Public Works, the Public Works would deal with the encroachment permit, but Mr. White here, and correct me if I'm misrepresenting you, would be, one of his people would be the person that would go out to do the inspection. And the feeling was, if there's a road there, and it substantially meets Chapter 810 or the state law, there's 10 or 12, that's up to you, we don't care. If it looks like people are putting gates and fences and stuff across it, you can tell a brand new road from a road that's longly been used. The only reason we put the term substantial in is it is a word that is used prior to the recordation of every final map in every county in this state. And it's up to the county surveyor to review the tentative map and the final map and make a finding of substantial conformance. And it gives him the judgment to make that call. There's no case law or no definition in this state of what substantial conformance means. It relies on human beings. And when we were talking about this with Jeff, she said, well, I go out and inspect this. What happens if I got, 500 feet of road that's exactly 10 feet wide, but I got 3 feet that's 9.2? He says, use your judgment. Give me a word that allows me to do that. Am I representing the property? Thank you. So that's the only reason I was put in there. If you don't want it, we make people go out there in wheelbarrows and lighten it up 8/10 of a foot. But our whole task was staying away from building a road from a lot removed from a public road through another lot, 2 lots, 3 lots, 4 lots, to if there's a road there, he's okay, as long as it meets the criteria. And somebody isn't complaining about it, because we would presume that the adjoiner, this guy builds a new road across his property, he's probably going to have him in court pretty quick, and that's where those things are properly adjudicated. And if there's no road there, that's a different story. Then he's going to have to build a new road, at least the way we're proceeding it now, to Chapter 810 or the state requirements, and he'll have to get a right of way.
Thank you.
Thanks. He's out looking at me today.
My name is Darren Borgadon, and I'm currently in litigation with the county over this issue. I had a guy from CDF come out to me last week, and he wrote me a letter, which we'll be going through the court procedures with anyway. You guys, as far as your guys' standard, CDF states that they have to have 18 foot to make it a legal parcel, in order to make a legal road to a parcel. And if somebody steals their way across somebody's parcel and don't wish to have them across their parcel, and they have a legal easement, it is up to the county, which they have not done yet in this case, require my neighbors to, and they are building on their property, they're doing it without permits, I put in code compliance things, nothing ever gets researched on my problems. But anyway, this guy's doing a remodel, and one of the county guys come out and tells them, well, just take pictures of it, because we're not going to come out here due to the litigation and the problems, and you can't get a permit until you can get your legal access. And then they pitted me against my neighbors, over giving these guys, and I got to service 5 or 6 people with hundreds of acres that have 3 or 4 parcel accesses legally to their own parcels, and they're coming across mine, and they did sue me for a prescriptive easement, which was about 10 feet wide. Well, the fire marshal states, and I got it in my prescriptive rights through the court, through the first proceeding, to fence both sides of the road. Well, upon him, I didn't have the money or the time to fence it, so I put rocks on both sides, and the county comes out with the sheriff's department and holds me at gunpoint and steals my property. Now, they won't give me a permit until I've been approached by the county stating if I give them a legal access, they give me a building permit. I call that, being pitted against the county again, And my kids still wake up seeing their breath every morning. I don't know, maybe if you raise your family in a refrigerator, you'd understand where I come from. But anyway, I don't have any rights until I fight the county out, because according to CDF or CAL FIRE, it's illegal for you guys to ask for this intrusion upon my property and hand it to my neighbors when they have their own legal easement, and what you guys have given them to their prescriptive rights is not legal enough for them to access their property at all anyway. So he's going to go back and make the county do the right thing. He says he overrides the county, and he's going to be involved in the court proceedings that continue on. We're set for the case management to get this thing going into trial on the last day of this month, But what I'm trying to state here is, if you guys ain't giving 18 feet, you ain't giving a roadway, you ain't doing anything. all you're doing is creating more legal problems for the individuals involved. And if the county was doing their job, because according to the county, they're supposed to, in order to issue a building permit, which they're already letting this guy back there remodel his existing house under what I assume illegal procedures, because he's allowed to take pictures of what's going on and give them to the county later on. So the inspectors don't even care whether they go out and so I don't know why we have these health and safety issues and codes when the county ain't gonna go out and inspect his stuff. He can take a picture of one plug and say, well, no, the whole house is done like that. It's all legal. But see, the reason why we go through this inspection process is to go over every inch of it, not to look at a picture. Okay, and the reason why the county is supposed to make sure before they issue a building permit that they're using their easements, okay, and this is another thing. They all have legal easements. Did one of them get developed to the county's deal? No. Why? Because it's all done illegally. Okay? But these guys seem to have special privileges from this county. And we're going to get to the bottom of it. I'm going to subpoena the CDA and the planning department because for some reason, you know, when I went through all this and they came out and red tagged me, they said that they had to have, you know, all these building permits and stuff brought up the car or whatever, and they required certain things. I went down and got everything for them. And then a month or two ago, when we went through this, they said, well, come on and we'll look into your situation and see what we can do for you. Well, all they had was my print. They had no engineering. They had no trust calcs. They had no plot plan. And I had to go out and start scrapping all this stuff together. And my attorney finally told them, you know, we're not going to get anywhere until we go to court. So let's just go to court and settle this thing. We're not going to deal with the kangaroo courts over at the library through the code compliance people and all that. We're just going to deal with it through Superior Court. Now, what I'm trying to state is we came up here we bought a piece of property, we plan on living on it, and we've been treated like dogs on our own dirt, okay? And it's all because somebody wants more of what we own than they have a right to, and they have other rights and obligations to get in and out of their own property under their own easements, and that's never been pushed on the issue. CDS said that this road, which is, somebody came out, and I don't know, here's another good thing too. I've got documentation where the previous owners took this direct room about 15 years ago, and you guys told Mr. Wainwright, my neighbor, the cult leader, to stay the heck off of this property, to find your own way in. Well then, now all of a sudden the county's saying it's their road. So I guess he's paid enough money to get you guys in his pocket or whatever, but the whole thing stinks. It stinks bad. Okay, and we're going to get through litigation, we're going to figure out what's going on, and we're going to decide the thing. And I'm going to have to subpoena every department in this county that's involved with this so we can get a direct take on it and get it done with, because you've already pitted me against my neighbors, I've already gone through the procedures, and according to what the judge said, and they all walked out saying, we didn't get enough. No, you didn't. But you have enough. Okay, one guy's got 700 acres next to me. He's got 3 ways in. What does he need? He needs a hole in his head. That's what he needs. Anyway.
Dare I ask, do you have a position on the matter before us?
Yes. Did you guys get a hold of CDF, and when you guys start granting easements, you get the full 19 feet of legal easement, and you look into the individuals to see that they do have a legal access, which is part of the county code, and that they develop that legal access, and they don't hinder their neighbor through a gravel road. If they have their own legal access, no matter whether it's an 18% grade and they have to put a hard surface down, it's not their neighbor's problem. It's theirs. And like they said, they knew that when they bought the property. And why does my neighbor get to build his house and remodel his house without the county going up and doing any inspection? Where's the special privileges there, and why? That's enough. Thanks.
Thank you. Would anyone else like to address the board?
Joe Kelly. 2 years ago, when the road ordinance was being updated, if that would have come to fruition, we wouldn't be here today, because there was so much just in the draft road ordinance that would not have allowed this to happen, or this auction would have had to go back and address the road ordinance to change it. I have just a few questions. What if there's a line of sight issue to a publicly maintained road? How is that addressed under 1704-030? That's addressed in other issues in the road ordinance. When you adopt this ordinance, will you contact the assessor's office to advise the assessor of the enforceable restriction placed on the servient tenement so that the assessor can basis reassess for the negative desirability effect and discrimination this ordinance will create? Has the county done an economic study of costs applicable for the servient tenement to protect the subject property? Now, this is away from the issue of this Legal Access Committee. My big concern is the Brown Act. Staff report discussion. Staff was also, this is a statement in that discussion, staff was also directed to establish an ad hoc legal access committee to consider the remaining legal access and road adequacy issues. An item left out of the tasking for the legal access committee was the inclusion of the Brown Act by the Board of Supervisors. The committee's agendas had a public comment or public matters not on the agenda item. This is being consistent with the Brown Act. During the tenure of the previous CDA director, Ms. Moreno, the Legal Access Committee meetings were publicly noticed on the CDA website. Under the leadership of the interim director, the public noticing was dropped from the website. I contacted the county administrative officer. He contacted community development agency interim director. He contacted county council. The response I received from the CDA interim director, it was county council's opinion that the Legal Access Committee was an ad hoc committee, not a Brown Act committee. County council was present during the Board of Supervisors meeting when the Legal Access Committee was created and tasked as a Brown Act committee. Why didn't county council express his concerns at that time? Where does county council get the authority as an appointed county official to override the Board of Supervisors' decision and the right of the people? I offer that the meetings not publicly advertised by the Community Development Agency did not provide a thoroughly transparent and participatory process anticipated when the Legal Access Committee was created and tasked. The stopping of public notices created continuous violations of the Brown Act. I request this information that's been given today not be allowed to be acted upon until the question of the Brown Act violations, county council's exceeding his legal status as legal representative, exceeding his status as legal representative to the Board of Supervisors is investigated and resolved. Thank you.
Would anybody else like to speak on this topic?
I'd like to just refocus and sort of, again, go over what we brought to you today. We started with a two-sentence ordinance that was very hard to implement. It's very confusing. What we brought you, and let's just kind of go down through these paragraphs, is paragraph A says, each use of land shall have access from a public road constructed to standards of fire and life safety. We reference 810 and the County Road Ordinance 1202, which should make public roads happy. Whichever is greater for the land use proposed, except for the following. Except. So what we have called out are four basic exceptions. The first paragraph is the exception for a single family residence, and this is clearly following the general plan. The second one is permits to remodel, repair, and replace existing structure or improvements. These are people that already have their house. If their house burns down, are they allowed to rebuild without dealing with this access issue? Permits for earthwork-related fire protection, site clearing, ag and livestock, erosion and sediment control, and drainage improvements. And then the last one is permits for the construction of new wells. Notice the call out, as Roger has said, to the January 1st, 91 date, which is when Public Resource Code 4290 and 91 went into effect, and specifically basically says anything built, any roadways used prior to that date are exempt or grandfathered, if you'll use the expression. Paragraph B, except for those exceptions in A above, all parcels requiring roads to be developed or improved to county standards shall demonstrate a right of access. Notice the term is not legal access, but a right of access from the nearest public road as indicated by recorded deed, parcel final map, court order, and the additions that Mr. Childs would like to see made. This ordinance is not going to solve every problem in the county. It is such a thorny issue that no matter what you do, it's always going to have thorns on it. Many of those thorny solutions are going to be civil, legal matters. But what it does is it provides 85% pressure relief valve for a majority of the exceptions and reasons that allow people that have invested in unimproved properties in the county to continue to exercise some use of those so that you don't have a huge number of people coming in here saying, I have unbuildable property. It also, coded in this framework, is an understanding of our unique historical nature of the roads, parcels, the land that came from the U.S. government patents in this county with over 150 years history. And we were cognizant of those when we created this. And I would say this is the committee's unanimous recommendation for an ordinance, with the exceptions noted today. And I would really encourage you to support it and at least keep us moving forward. Thank you.
All right, to bring us back, I would like actually to ask staff to, if you have any answers to some of the questions that came up, or any response on the question of the Brown Act and our observation of that, or a need to in this case.
In staff's opinion, that issue has already been addressed. So at this point, there is nothing further to address with that. We have dealt with that through council, and as far as staff is concerned, it is behind us and not an issue. Relative to the other changes in the codes, staff would recommend that you incorporate the two that were previously addressed by Bruce Child, County Surveyor, and you'll provide corrected clean language for your second reading. Third issue, and I think it's one that has been touched upon by, addressed by the road department, and to the extent the committee. This ordinance is not intended to add road sections or templates to the county road ordinance. This really is intended to be a factual finding of existence of an existing road. So, and the only standard we have is the width. So it is not a matter of does this road meet 1492 standards, because these were created prior to 1492. And these are exemptions from those issues. So we're not looking at trying to have a new road standard that meets all future requirements for construction purposes. This is supposed to be a factual finding relative to existing parcels served by an existing road. I think when we talked, we envisioned that in fact the chief building official or his designee would be the one that was doing the determination, since the entitlement that was requested was a building permit. If you choose somebody else or you want that clarified, the simple answer, and literally at the very end of the first, last sentence of number 1 is you just add the words to the approval of, and then you put in the official, chief building official or county surveyor or public works. Staff would certainly concur with the recommendation of the committee that it should be the chief building official. Again, we're not talking about designing and building new roads. We're talking the factual finding of, is it there? That little phrase, to the approval of, is literally added to every condition the planning commission sets, because at some point, when a condition is set, whoever sets that condition has to decide, having written that based upon my understanding of the facts when we started the process, as opposed to having gone through the engineering and all the other development issues, has my condition been met to my satisfaction, in the sense that if the road suggested it had to be, for the sake of argument, 6 inches of gravel or subbase over 6 inches of base, and the county surveyor gets county road engineer gets a report that says, I don't need 4.5 inches of subbase, he can say 4.5 is fine. That discretion is there, and it is always there. And it's there for the health department, it's there for any agency that sets a requirement. Has that agency's condition been met? If they agree to it, it's agreed to. So clearly that language, if you're uncomfortable or want to have somebody clearly assigned, I would just simply add to the approval of and probably the chief building official. And those are very minor changes. They don't affect this ordinance in terms of what it's attempting to do. And again, we are trying to get to a solution for pre-existing issues. We're not dealing with road improvements in the future. Everything else is covered by codes and so on. So we're trying to deal with an existing set of problems, and hopefully this answers those.
Before you leave the podium, I've got a couple of questions that came up during discussion. The first of which was raised by the committee chair regarding the extension of the sunset clause date. It appears that we would not be able to implement this ordinance until after the second reading, and that means that we would have expired at the end of this month. Do you recommend that we extend the sunset date, and if so, to when? Secondly, there was the issue of fees and the old records and accessing those and figuring out a protocol and cost for that. Do you have any recommendations for regarding the need for that, and any instructions that you wish to be issued to staff on that topic? And finally, there seemed to be some, I'm not sure what the consensus of the committee is, but there seem to be some distinctions between the 10 and 12 foot issue and whether that needs further attention and reconciliation. Those are the three that I gleaned from this, but you may have more.
Okay, in inverse order, the 10 foot is clearly the item that we are dealing with. That is very clear on its face that we're talking about a 10 foot standard for an existing road serving existing parcels. So
all right,
that's why we struck that. That's why we struck that first piece of code section to avoid any confusion.
Okay, notwithstanding Public Works comments on the topic.
Correct. And again, it's a matter of focus. We're not talking about adopting a standard to build new roads. We're talking about finding as to whether an existing road meets that 10 foot standard.
It's the grandfather,
The grandfather.
1991, all that.
The second issue.
Just trying to clarify that.
The second issue is outside of the scope of this ordinance. That's why I didn't include it in the discussion, and it's something the board should consider. Inherently, the risk of losing historical documents is significant. I can't tell you to spend the money. We've got documents in our department we would love to get microfiche and get safeguarded, because we have them in inappropriate storage also. It's something the county has to face, but it's really beyond the scope of this discussion, so I would suggest that we put that on for a later discussion. And I know we've done it before. We talked about archival, trying to deal with not only archiving, but condensing the storage problems and getting the retrieval system. So it's a topic you're going to have to face again sooner or later, so I'll let you have that one on your own.
So you recommend commencing with that
after
you retire?
I lost the first one, Mr. Chairman, of your three. Which was the first?
Sunset.
Oh, the sunset issue. If you adopt this as a first reading, I think staff would be willing to take a risk and use their own discretion and advise somebody, their permit probably shouldn't be issued until the effective date of this, after the second reading, and we would not obviously try to enforce a code section that is in the factual process of changing. If you need to extend it, you would probably have to come back the first of the year with an emergency ordinance at this point to grant an extension, because if nothing has been agendized, I don't know if it would qualify as an emergency ordinance at this point or not. I think the practicality is if your board agrees with this general direction, we're not going to go out and try to implement something in a matter of a 3 or 4 week period where we can go out and grab a citizen and say, gosh, that's not our job, and that's not our intent. So I guess I would say trust us on that one as long as you do your part with yours.
All right, thank you. Any comment from county council before moving forward?
I think I've already addressed the Brown Act question. I'd be happy to move ahead if there's any questions from the board, but otherwise, I don't see the need.
I guess from my perspective, since there are people listening to this on delayed tape, that it would be good to explain our position so that people are aware.
The Brown Act applies to local legislation. The question is, how do you define a legislative body? Obviously, it's this board. It includes, and I'm quoting from section 54952 of the Brown Act. It includes a commission, committee, board, or other body of a local agency, whether permanent or temporary, decision-making or advisory, and here comes the important part, created by charter, ordinance, resolution, or formal action of the legislative body. When this board appoints a committee by resolution or by ordinance, it is a Brown Act committee, no argument there. This group was appointed and designated by the Community Development Agency. It is not a Brown Act group.
Okay, so while it did operate for some period under on a voluntary basis, it was not a requirement. All right. That clarifies the matter, and I thank you for that. All right, let's move, if there's no further public comments on this, let's move to board deliberations. Who would like to go first? Yes, we'll move to the senior supervisor.
Well, my position hasn't changed, and I haven't heard anything. It should change it. And in my opinion, basically having legal access is just a basic required entitlement before you build. We have lots of parcels out there that do not have legal access, and we're having problems. Well, just build your $300,000 to $500,000 home on them, and then see what the level of the problem is. And that's what we've done at the end of the Roller Road, and that's what we've done at the end of other roads that do not have legal access. And if that's going to be a basic public health and safety standard, which the road ordinance is, then I think we should apply that county public health and safety standard to all new buildings equally. I see no reason to basically cut the baby in half in 1991. That makes no sense whatsoever to me. I mean, Dave Wood stands up and talks about our unique and historical nature of our roads. Well, that may be fine on your 10-foot pothole dirt road that's being accessed for agricultural purposes. But once you build a residence out there with mom and 3 kids and dad, it is no longer a unique and historical nature of that road. That nature will change, and we're going to have nothing but problems. The people that live out there are going to want the fire trucks to show up, or the ambulance to show up if dad or mom or somebody has a medical emergency. And that's why we have the standards we have. Those standards should be applied, and I think they're good standards. And because we have made, in my opinion, mistakes in the past, there's no reason to bury our heads in the sand and say, well, we're going to continue to make mistakes in the future. I mean, you can basically say, well, just go out and look at the road on your neighbor's property and measure its width. Well, it seems to me the neighbor, that owns that property should also be contacted and have some input. He should be able to basically say, no, I have a right to change the width. Or, no, it serves as a vacant lot that is leased out for running cattle, and building a home on it's overburdening that road. I mean, we're being sort of typical government in the sense that one of the primary responsibilities and purposes of government, in my opinion, is to protect property rights. And yet we're saying, oh, you can go ahead and trespass against your neighbor as far as access. And we have no problem with that, but we're going to get you to sign a disclaimer that says, you know, county government has nothing to do with this. You can't come back and sue county government under some implied consent that by issuing the permit or even creating a parcel the county has somehow granted you an easement over your neighbor, unbeknownst to your neighbor. And we have that all the time. When we have this argument, we had it earlier. We have people come in that have legal parcels that do not have legal access. And their argument was, my God, you allowed us to create this parcel, you have an obligation to make sure that we have access and we can build on our parcel. Well, what do you think is going to happen after they build their $300,000 to $1 million home on this parcel? Then they're going to be in here even more adamant, saying that the county not only created the legal parcel, but issued the building permit, and we have an obligation to see that they have access to their property and have a right to trespass against their neighbors. That makes no sense at all to me. We all talk about agriculture and sprawl, and geez, we're all pro-ag, and we don't really want all this rural sprawl. Well, this is an anti-ag, pro-rural sprawl ordinance that's in front of us. And it sort of amazes me that, you know, we have the general plan, et cetera. We have all the environmental groups out here. We have the Calendars Coalition, and we have Thomas and Fusimo, their attorney, and we have CAP, and we have other Task Force Watch. And we get down to the real nitty-gritty stuff. And to me, this is so basic for any development, for any building. And yet, do we have one word from an environmental community person here when it gets down to rural sprawl and just your basic entitlements? Not one word from anybody from the environmental community. And quite frankly, in my opinion, it's because they don't really give a damn about the environment. They use that environmental organization for other political objectives. And you know, it's always just appalling to me when they show up, but even more appalling is when they don't. So that completes my comments. I will not be in favor of this
ordinance. Would anybody like to go next? Supervisor Thomas?
Yes, Supervisor Orlinski, I would like to weigh in on this. I feel very much at opposite poles with Supervisor Tryon.
That's why we set you on the bookends of this thing.
The clause in the existing general plan that says that if you have a single family, if you have a parcel, a legal parcel, it doesn't talk about whether it's got a 10-foot, 18-foot, what kind of road that it has to it. But if it's a legal parcel in the county of Calaveras, you have a right to build a single family residence on it. I think that's where I'm focusing on. And I don't know, someday I'll have Supervisor Tryon define for me what rural sprawl is. I mean, the creation of a single-family home on a remote 40-acre parcel, I think that's not something that we should all be, my God, we're going to build another house on a 40-acre parcel and avoid it. I think that's one of the things that makes this county unique and very desirable to live on, and we should encourage that. I think my responsibility here is to enforce the existing general plan and to clarify where there have been problems in the implementation of that general plan. I think that's my job to try to see that gets resolved. I have attended at least one of these meetings, and I want to say, David acknowledged the participation of the members of the committee, but I want to draw attention to the fact that David Wood was always organized, always on target, on track. What we have here is in large part a result of his diligence and devotion to duty, and thank you very much for doing that. So, I'm going to be supporting this with the revisions that have been brought up today, the exclusions and additions, minor ones. I think it was a good effort. I think that sort of as a template for future things. The board clearly doesn't have an opportunity to woodshed these thorny issues, and we have so many bright people in this county that are highly motivated to help us and to do good work, and you keep coming back, and thank you very much for that effort. So anybody else?
Thank you, Supervisor Callaway.
I have some more concerns with the ordinance, so I read point one. The disclaimer doesn't really mean anything. I really feel like it is putting the onus back onto the county. That is not where it should be. It should go with the title. There was nothing said how would that be handled. It was mentioned that it will be recorded, who's going to do that, who's going to pay for that. What happens if the disclaimer is not done? I did appreciate the committee saying it should go to many different departments, environmental health, building planning, and recognizing that. But the county is not the guarantor to access to parcels that have been subdivided. And I think by accepting this ordinance, we are going to be taking by default this responsibility. Supervisor Tryon reminded us that when the issue came up, people were in here upset because we allowed parcels to be subdivided, but they didn't have a legal access to it. And
Why doesn't anybody?
I have the floor,
Excuse me,
please.
this is
I have the floor,
deliberation.
please, thank you. So, all this is going to do is put the onus, again, whether the county likes it or not, back onto the county. I feel like I need to vote in terms of what I think is good public policy, not in terms of what is expedient. We've had roads in here that have come before us that have not been adjudicated, that are 8 feet wide, and even some that have been adjudicated, and should we allow them to be built? Per this ordinance, proposed, if it's 10 feet, then you can. So does that mean if it's 8 feet, even if you have an adjudicated road, it cannot be? The issue of driveways, roadways came up. I think that's significant. That's a reoccurring issue. I do not support the word substantially. It either is or it isn't. And it can always be brought to the board for a variance, as other things have been brought to the board before as a variance. So I think it's a fuzzy word, and we need to omit that. The issue of going into CC&Rs, deed restrictions and so forth, that was not something that the committee had been charged with. I don't even know why it is in here. It just doesn't belong as far as I'm concerned. There's nothing in here that really, unless I'm missing it, which is a possibility, defines what a legal parcel is. Some of these parcels were established, as was alluded to in the 1800s, early 1900s, and it just has sort of meets and bounds descriptions, and there's roads going to it. Is that really a legal parcel? Should we define in here what is a legal parcel? When there is whether there is an ingress or egress, is it exclusive, is it non-exclusive? And what happens then when the parcel owner then wants to subdivide the parcel? Will we then require whom to obtain legal access? I think we're beating around the bush by not using the term. And I don't think that this county should be in the business of being the liability shield for access to their parcel. You know, the responsibility, I mean, we have this whole, the responsibility goes with the buyer of the property. But as all of us know, with the mortgage crisis, we all sign documents and we don't know what we're signing. And the issue really needs to be where the realtors, the title companies, and the buyer of the property. There is more than I wanted to learn. There's a title report that's the CLTA, and Mrs. Whittle can please correct me, it's the California Land Title Association or the American Land Title Association. If this county wants to allow buildings, homes to be built without a legal access, then my feeling is that people should have an American Land Title report, which ensures that the property can get legal access, that they can go to court, however. But in California, most of the title reports are CLTA versus the American Land Title Association. And I keep reading this and I keep seeing the responsibility coming back to the county, not what belongs with the buyer of the property. So I cannot support this. I think there's too many loopholes. Now, to the positive side, I apply this to where you have a vacant parcel and you want to build a single-family structure. Where there is a single-family structure already in place, I don't have a problem because the horse is out of the barn and building a garage, replacing a well, or replacing a septic system. Because there's already something there and there's already the inherent risk has been bought into. But where you have vacant lot and you now want to do something new to it, I can't support that. And I would give another example in my district where I happen to not have these problems, of course, is in the Lakemont Pines subdivision. There are about 8 to 10 parcels that have a lot, that have a road servicing them. These are small parcels. They're not the 40-acre parcels that Supervisor Thomas referred to. The owner of a parcel at the very end of the road said you can no longer access the county road through this existing road that goes by my house because you don't have legal access to it. So the property owners, the 8 to 10 property owners, are now trying to negotiate with each other to build a new access road coming into a county road. Just because a new owner of the property said, unless, you want to pay, widen, do whatever, you cannot cross my property any longer. So now all these property owners that have used this road for probably 30 or 40 years are having to come up with another option. And these are the things that we're going to buy into if we approve this ordinance as written. Thank you.
Mr. Chair, could I interrupt briefly?
Yes.
Because I think I need to correct something I said earlier. Supervisor Calvin is correct. I referred to recording this disclaimer, and I think that's in error. I don't think it's contemplated that it would be recorded. I'm not sure that it's even a recordable document. So our review was the language to see that it adequately put the applicant on notice of the limitations of the building permit, but I have to withdraw my comment by recording that.
And Mr. Jones?
Yes.
If this isn't done, you know, when somebody forgets or somebody doesn't do it, then what? I mean, so that's why this puts the onus onto the county. It does not put the onus where it belongs. Thank you.
Thank you. Supervisor Claudino.
Well, I don't have a great deal to say about this issue of legal access, or passive access, but start off by saying that I do support staff's recommendation of the work of this committee, which is fine, what you want to go. Thanks. And the reason, I mean, I have some respect for the comments made by the folks that don't agree with me, but this issue is never going to go away. I don't believe there is a panacea solution to it. The old saying is, you know, everybody wants to go to heaven, but nobody wants to die. So once in a while, somebody has to make a decision and live with it, or nothing gets done. My tenure on the board, generally speaking, the board is pretty good at telling people why they can't do something, better than telling people how and why they can do something. And this issue is important. We know that because it was overflowed with people when we began discussing it. Authorized the ad hoc committee of people who are, if not experts, certainly more knowledgeable than, in my opinion, most of the people on this board. They worked hard and diligently to put this together. They have the approval of staff. These people are professionals in their vocations, so I give great credibility to that effort. With regard to property rights, I wholeheartedly agree, because if I own a piece of property that's mine, and I would like to go home on it, I regard that also as property rights. And from the admittedly relatively limited research that I've done, but I have done some, most court cases will ultimately allow people access to their property. It's pretty hard to landlock somebody in this state, from what I have seen. So if there's a legal parcel, I think there is some right to build on, and also a right to gain access. Now, this may wind up in litigation somewhere, but I'm telling you that from what I can see, most of the time that is granted. Anyway, so rural sprawl is something that, you know, that's a bad word these days, and I agree with that definition. But for me, rural sprawl is when you indiscriminately divide property. If I already own a piece of property and it's been created a parcel, it might have been a parcel for 10 days, it might have been a parcel for 100 years, or, you know, in my case, I do own a parcel. It's been a parcel for 140 years, and it was created. You know, it's still a legal process, but, excuse me, a legal parcel, and that parcel, with the ownership of that parcel, I believe comes some inalienable rights, and that would be to use my parcel. And to not be allowed to use it is tantamount to the taking of it. That's simply my opinion, but that's how I look at it. With regard to the disclaimer, I don't agree that it means nothing. I do agree that perhaps it's not shouldn't be a reportable document, but I have lost track, even with all your computer skills over there, you probably couldn't keep track of the number of times people have come to the county and had a project go bad for them or not the way they intended, and they say, I didn't know, whatever it happens to be, I didn't know. The disclaimer has a very valid purpose in this document, so that at least people cannot say, well, I didn't know that. So it may not be a reportable portion or a reportable document, but I certainly think it has value. With regard to the historical nature of this, the 1991 issue, you know, I'm not an attorney and I'm not a legal research person, but in my working life, I have dealt with many, many codes in California, legal codes. And I can't think of a code, or even certain enforceable portions of any code I've ever dealt with, that does not have some historical dates in it. Because as we, you know, as time goes on, things change, and I think it was alluded to as maybe a worn-out phrase, the grandfather. There are many, many statutes in the state, and many, many codes that are date-sensitive. So at some point, you need to stop, perhaps the old procedure, and start a new procedure, at least when deemed necessary or appropriate. Well, those are basically my points, and I do support this ordinance. So the modifications that we discussed earlier, the county surveyor and the planning director, and I think the fact that this committee was put together from professionals from various walks of life and professions, and they came up with a viable solution here. I think to massage this any further would be mountain climbing over molehills, and I think we need to adopt this and go forward with it.
Thank you, Supervisor Clavina.
I just want to get a clarification, maybe from council.
Sure.
Jim, I mean, Bill said, you know, I didn't know, so people sign the disclaimer. But then there are 3 property owners down the line, they didn't sign it. And unless you record it, where is the protection from the client? I mean, otherwise it's just a document that the property owner signs, pulls a building permit, doesn't build.
I think the disclaimer is a little bit of a belt and suspenders. I'm not sure that we need the disclaimer to insulate the county from liability. I think the purpose of the disclaimer is to communicate information. I don't think that the county has liability because, again, it's pretty fundamental that granting a building permit does not establish legal access. The problem is, again, the perception that that's what happens. So, I guess that's all.
Thank you. Well, as I read it, we have 2 who are opposing this and 2 that are supportive. Making these comments, I guess, determinative. But before I cast my preface, I want to preface that with some observations. My district is full of dispute. This board has been regaled with legal access disputes, not only prior to this date, but even on this date. We have neighborhoods that are fighting over legal access, and the only advice to this point that the county gives is to go sue each other. We have neighbors that use county offices, county departments, the sheriff, animal control, code compliance, building department, planning department, ag department, that are beset by disputes over our failure to deal with this issue. So one of my first questions in approaching this is sending all of this to court, that being our best response to these communities, is that really serving the interests of these communities? And my answer is a definitive no. I've watched several neighborhoods actually litigate more than once against one another and still not have it resolved. And even when it is resolved legally, it makes for a worse neighborhood in the end. With all due respect to the attorneys in the room, I'm just not sure that your venue actually improves neighborhood relations at all. A second issue is one that I take very seriously, and it weighs on the other side of the issue. Supervisor Tryon is correct. We've had an inattention in the land use arena to try to make for effective towns, we've managed to stretch our infrastructure, roads, water, sewer, to the point where we have still others coming and besetting this board with unresolved problems around all 3 of those issues. And as regularly as several of you have, know that we've done a pretty sorry job of planning land use to make for sensible, efficient, smartly outlaid communities. My district is probably the worst of it. In one of the we stretch out over what roads are buildable, and we've had years and years of handshake agreements between people who first built the driveway to their place might have bequeathed it to several generations of family. There being now 3 or 4 houses on 3 or 4 parcels. The driveways gradually become shared. The understandings are informal and handshake in nature. We have BLM and federal lands that people cross with very shaky understandings or just history. We have mining claims all over the darn place, which complicate this even further. And when I first addressed the committee, I think I had 14 different classifications or classes of interest here that I see at least a few are resolved by your efforts. I don't believe that that anything we can do will keep people out of court if they want to fight each other. But I do believe it is important for this county to give some very clear, or as clear as we can arrange between ourselves, language that keeps at least some of this out. And so for that, I applaud the committee for its effort. I don't think this was easy. I think that people, once coming in, having shaken their fists and brought the pitchforks and torches to this chamber, those that were assigned to have to delve into this issue began to realize the complexity and full measure of it. And I don't think that even this set of compromises will fully address all of the matters here. But I would suggest the following: that the more people we can get out of court, the better. Number one. So the grandfathering of pre-1991, it would be nice if we could retro-do a smart and clear arrangement, but that's not an option available. That's very idealistic, and it's a worthy hope, but it's not something that we can actually do after the fact. So the grandfathering takes a good number of disputes out of court and resolves it. The exceptions that are added to this take, and the surveyor's suggestions take yet more, lend more clarity to other neighborhoods. Will the ones that are currently engaged in the practice and have deepened their divisions gain some measure of clarity from this? I doubt it. And I'm sorry for that. I would really like to see an ordinance that fixes all that ails us. But on balance, and with respect to the due diligence and hard effort of people who struggle through this, I will lend my name in support of this amended ordinance. Let me also add to that I believe that there are some things that need to be done as follow-up. And let me been writing notes on this. First, I do think that we need to, because I struggled with this with a lot of my constituents, I think we need to get all our records into shape so that we can access them. And I think the failure to do so has led to a lot of confusion and a lot of us, we shrug our shoulders and say can't help you, when in fact we have documents that would. And my hope is that we can arrange for that access and that we can update our technology to be able to afford that. I want to know what the cost will be. We're in tough times, and I want to know whether there may be a staged implementation for that, but I think we owe our citizens the full access to all records that we have, and we need to try to expedite that. So I welcome Selman's suggestion that we take his post-retirement years, and maybe he would come back and help us with that. Second, I doubt it. On the question of the disclaimer, I actually don't find any of the documents in front of us very helpful in figuring out how we're going to distribute that, where we're going to distribute it, what our understandings of that conveyance will be, and I would like there to be a staff follow-up from the department promulgating this to be very specific about how we will present it, what kind of staff training we will have so that everybody's conveying the same information. I do believe that the concern that Supervisor Callaway raised You know, if we handle this, if we muff that, we're just compounding our issues or our problems. And it would be good if we could do this crisply, clearly, and with an implementation measure to follow that up. Finally, just a comment on the substantially, the word substantially. I don't think that's a very good term of art, but I recognize the compromise nature of it, and I know that the U.S. Constitution was created in similar ways and has resulted also in a whole lot of litigation further defining it. But I think it would help me, and I hope that my fellow supervisors will accept the language that was proposed following substantially to the approval of either the chief building official or the director of public works or their designee. And so I don't know which, and I'd like to hear from the board where they think this should go, but by my thought, because roads, and because most of this involves roads, not driveways, that certainly for roads, it makes sense that the Public Works Department have some jurisdiction in the interpretation. Lastly, on property rights, this is a property rights issue that cuts on both sides of it. We have people who have built and been historically, 4 generations in, having somebody move in on a road in front of them and gate them off from their property. I find that to be rude and in need of clarification and hopefully moving away from that approach. At the same time, I find people who have lived in a place and have somebody trying to build some subdivision behind them, and actually this is how this, in the ag issue, it's significant, and I don't want to see farms and ranches trespassed upon as a result of this, which leads me to my final comment. We need to resolve the issue of rural sprawl, of impingements upon agriculture and the open spaces of this county by careful attention to land use planning. It's part of our general plan, it's part of our community plans, and we need to take this issue on in that way. And if this interpretation of this becomes an acceleration of that process without dealing with it in that other arena, then I will be the first to move reconsideration and revocation of it. That said, my vote will be yes, and I ask the board whether they would agree to the language relating to who would define the word substantially.
I think maybe consider this rewarding there, rather than mentioning the department somehow. The idea of this being the department that has primary jurisdiction. Because you're doing roads. It is. You're going to put all that in there. Mr. Miller explained. Road, public works, driveways, building department. You have 2 departments here.
We'll go one at a time on the subject. Supervisor Quilly, your approach would be to make it the appropriate department.
Department with primary jurisdiction.
With primary jurisdiction. Supervisor Callaway and
Yes, I haven't been in, and I'm first to let you not like the word. I think it should be yes or no, or then you will apply for variance.
Okay, but